Live across Queensland, this is 7 News with Max Futcher and Sarah Greenhalgh.
Good evening.
No, that wasn't an earthquake hitting 7 News in Brisbane last week, but you had to look carefully. It was just a rogue robotic camera having a wobbly, so to speak. Hello, I'm television and radio producer-presenter Rob McKnight with over 30 years' experience. This is Media McKnight. But it wasn't just the robot camera struggling this week. You have to feel sorry for this camo who was covering the Jackie O trial.
How is Jackie doing?
You're right.
Yep.
Yeah, his embarrassment there. It's certainly a tough job when you're trying to walk backwards with a camera and see where you're going. Covering news certainly comes with its challenges, and newsrooms were put to the test today covering the Victorian leadership spill. Sky News, now rebranded as News 24, usually covers breaking news very well on days like this. But today, things just didn't go according to plan. News 24 missed the announcement that Ben Carroll had been victorious in claiming the Labor leadership from Jacinta Allan. They were playing an advertorial at the time. Watch this side-by-side comparison with ABC News to see how badly it went.
And here we are, so we'll just stand with us as we have a look.
I am delighted to announce that we have
Ben Carroll
Ben Carroll has been unanimously
Parliamentary Labor Party as our next Premier of Victoria.
I am also delighted to announce that Gabrielle Williams will be our Deputy Premier. I want to thank our former Premier, Jacinta Allan.
Now look, the ABC were obviously having a few issues with different microphone feeds, but at least they aired the result live. Let's isolate the News 24 feed and show that moment again for pure clarity.
Plus, get the bonus digital recipe book when you order from Global Shop Direct today.
When I first started going blind, I didn't want to go out. I thought I might walk in front.
We're
taking you live to outside the Victorian Labor caucus room. Let's listen to the result.
I want to thank our former Premier, Jacinta Allan, an extraordinary person who has contributed so much to the Parliament of Victoria.
I'd say missed it by this much, but it wasn't even close. This is why the line producer role in the control room is vital during breaking news. Everyone on the team should be feeding into that person so they can make informed decisions about where to go next. The ABC reporter covering this event knew the caucus meeting had to be done by midday, even making this point.
Everyone's checking their phones to see if there's any firm updates from that. But look, they've got to leave those doors soon because Parliament's sitting from 12 o'clock onwards. So this is always going to be a 2-hour meeting.
So it was well known the meeting had to end at midday, which makes this decision by News 24 all the more bizarre.
Trudy, thank you. We'll see you in just a couple of moments' time, and thank you for your company at home for this rolling coverage of this Victorian Labor leadership chaos. We'll see you soon.
Life is full of uncertainty.
Well, life may be full of uncertainty, but not everything is uncertain because it was known Victorian Parliament was sitting at midday. So why you'd decide to go to a commercial break at 6 to midday is just crazy. Look at that, 11:54. They went to commercial break at 11:54, and let's not forget, the news breaks on News 24 are about 5 minutes. They're pretty long. And then you have to wonder why it took so long for the control room to bail out of the break. But it wasn't just the announcement that went wrong for the rebranded Sky News. Earlier, a major audio malfunction made it hard to hear what hosts were actually saying.
What, Andrew, James, there's not going to be an actual count or anything like that. It is a...
Yeah, unopposed. But, I mean, I'll tell you what I found interesting, Laura, actually, and I saw you looking at it.
that footage of Carroll walking in, he wasn't exactly smiling.
So that audio from the studio seems to be coming from a low-level mix minus feed. But there's this.
That's nonsense. I mean, she didn't have the numbers in the caucus. Whether or not she would have won in the party ballot, in the membership ballot is academic. I mean,
as you can hear, the audio from the live cross in Melbourne was perfect. Okay, they're having some audio issues, but the extraordinary thing here is that this went on for 6 minutes and 48 seconds. I've fast-forwarded the vision. Watch that clock at the bottom just keeps climbing. Now, eventually, they threw to a package about Jacinta Allen, which gave them the opportunity to fix the issue. But how is something like this allowed to air for 6 minutes and 48 seconds? And when it was finally noticed, why keep airing it? Why not just get the person in Melbourne to take over, or tell the reporter on the scene that they have to host the coverage for the moment while the problem is sorted? This is just amateur hour. And it shows you how important the person in that line producing chair is when things go tits up, because they're the ones who can make tough decisions and hold it together. None of this had to play out the way it had. Yes, look, you have audio issues. The first thing you ask, you've got to be listening. Obviously, no one was listening. The control room, whatever they were doing, they weren't listening to the main feed. But why wasn't the audio director yelling out? And why didn't they say, okay, what are our options here? And as I said, you say to the guy in Melbourne, you just keep talking, studio's dead, we've got no audio. And you tell the host, don't jump in, we can't hear you, we're trying to sort it. Then you get the reporter in Melbourne to say, we need you to host the coverage, we're going to throw to you. You say to the guy in Melbourne, who was the live cross, throw to the reporter on the scene, and you just keep going until you can sort out those issues. 6 minutes and 48 seconds? Give me a break. I mean, seriously. And I said, Sky, which is now News 24, usually do breaking news well, but on a biggest day, this is probably the biggest day in politics this year in Australia, they failed.
I think the challenge was...
Turn your podcast into a TV show.
Oh, I love this.
For just $80 per hour, you can have your host anywhere in the world.
The mandates are off in America here.
With graphics tailored to your show.
Can I just dispense with all of the emotional kind of foreplay and just jump in? Do you mind?
Video Podcast Services is run by media professionals who know how to make your content stand out from the crowd. Go to videopodcast.online.
And speaking of news, 9 News Melbourne has claimed the ratings crown for 2026 following recent wins for 9 in Sydney and Brisbane based on the traditional 40-week survey. The Melbourne News team just clocked up win 21, meaning they can't be beaten under that metric. I've always lived by the weekly win scenario, but that's becoming problematic with ratings available all year round now. But 9 has also revealed average audiences from the year, and on that metric, they're also coming out in front in those markets. In the 2026 survey year to date, 9 is winning in Sydney 248,000 to 209,000 for 7. In Melbourne, it's 278,000 to 7's 255,400. And in Brisbane, it's 224,000 to 158,300. 9 also put out the 5 city metro figures, but they're meaningless now, quite frankly. New services are local, so it makes sense to judge each network city by city. But if you want an overall figure, you have to go national, all people. That's the metric now, as determined by the networks themselves. No more of this 5-cap city. Nationally, 7 News holds a commanding lead thanks to Adelaide and big wins in Perth. It's certainly been a comeback for them. Things started faltering. They were going down over the past year, but they've re-energised. They've come back, and 7 News holds a commanding lead. But quite honestly, when it comes to the 6 p.m. news, it should be judged city by city. So a big congratulations to 9 winning Melbourne, Sydney and Brisbane, and therefore the East Coast. That's really impressive. Those big wins in 7 in Perth, geez, they keep it going over the line. Has Kyle Sandilands thrown Jackie O under the bus in her court case with ARN? And did he do it on purpose? I think the answer is yes, but I'll get into that in a moment. The judge in Jackie's case has ruled the affidavits filed by Kyle and his manager Bruno Buchet can be used by ARN in Jackie's case. But Justice Stewart seemed confused in his ruling about why Kyle and Bruno actually filed affidavits just before settling their case with ARN. His judgment seemed to indicate they did not need to provide them at all. There's a lot to discuss here. To take us through it, I'm joined by employment lawyer Michael Byrnes from SWAAB. Michael, welcome back to Media McKnight.
Hi, Rob. Good to see you.
Always good to see you, my friend. Let's go through this piece by piece. Why has the judge allowed the affidavits of Kyle and Bruno to be used in Jackie's case?
Essentially, because the protections that sometimes apply to documents and affidavits filed in proceedings, that is that you can't use the documents or affidavits filed in the proceedings for other purposes, that didn't apply to these particular affidavits, and therefore ARN are free to use these affidavits in Jackie's proceedings. There's something called the Harmon undertaking, without getting too legal about it, legalistic, something called the Harmon undertaking, where if a document or evidence is provided under compulsion in a proceeding, then it can't be used for another purpose. And so what the judge was saying here is that that principle didn't apply to these affidavits, and ARN are free to use them in Jackie's proceedings. That's what this application was about. This is a key point,
and I want to get to this, but before I go down that rabbit hole, because that's really fascinating, Kyle and Bruno objected to them being used in Jackie's case, but Justice Stewart made this point, saying, by correspondence from their solicitors, Johnson, Winter, Slattery, which they have requested to be placed before the court, the Sandilands parties opposed the relief sought by the respondents, but they have not appeared or offered any submissions other than what is in the letter in support of that opposition. So I know I may interpret things as a layman differently to a lawyer like yourself, but that sounds to me like he's saying that while Kyle and Bruno objected to the affidavits being used, it wasn't exactly a vigorous defence. That's my takeout.
I don't think that's the conclusion to draw, Rob. The correspondence that was tendered certainly suggested a strong opposition from Kyle's camp via the letters from his solicitors to ARN's lawyers. So it certainly spoke to a strong opposition. I don't know why they didn't appear. If I had to give
offer any submissions other than what is in the letter in support of that opposition.
They did ask, and they did ask that the matters in the letters, which are in the form of submissions, were drawn to the attention of the court, and they were. And so the judge would have had regard to them. If I had to guess, and I guess I do because you're asking me to speculate to some extent, I'd just say that the view taken by Kyle's camp is that as far as they are concerned, these proceedings are over. They're settled, they're done, they're dusted. They don't want anything more to do with it. And so they don't want to feed into this idea that there's still unresolved issues or residual issues by turning up for court and arguing the matter further and incurring further costs, etc. They've made their opposition clear. It is what it is. It's ultimately a matter for the court.
Well, this is where things get interesting because we come back to the point you were getting to earlier. Let's talk about the timing of the affidavits. Justice Stewart laid out a timeline that seems to show there was actually no reason for Kyle and Bruno to file affidavits at all. He says an extension had been approved for the affidavits to be filed by the 10th of June, but they weren't filed by that date. Then he goes on to say, on 16 of June 2026, that's 6 days later, the solicitors for the Sandilands parties provided a draft form of deed of release to the solicitors for the respondents. Less than 2 hours later, the solicitors for the respondents delivered to the solicitors for the Sandilands parties a deed of release executed by the respondents in the same form in which it had been received from the Sandilands parties. Around 10 minutes thereafter, the Sandilands parties electronically lodged their affidavits with the court for filing. About 15 minutes after that, the solicitors for the Sandilands parties delivered to the solicitors for the respondents a deed of release executed by the Sandilands parties in the same form that they had earlier proposed and which had been executed and returned to them by the respondents. Then later in his judgment, he says, there is no explanation as to why the affidavits were nevertheless filed. Conjecture as to that reason will serve no purpose. The relevant point is that the information in the affidavits was not disclosed under any form of compulsion. You just a moment ago brought up that under form of compulsion. Talk to me about that.
So this harm and undertaking principle, Hernan Street is the case, it only applies to evidence or to documents produced under compulsion. There have been recent clarifying authorities that make it clear it's only documents and evidence under compulsion. The circumstances in which these particular affidavits were filed, and there are two, one from Kyle, one from Bruno Buchet, Kyle's manager, they were not under compulsion. And to establish that, the judge in his judgment explored the relevant timeline, and it was determined that they weren't under compulsion because there was no requirement to file the affidavits because the matter had settled. And indeed, these affidavits were filed pretty much, as you can see from the timeline outlined by the judge, contemporaneously with the settlement having been effected. There was a deed presented by the Sandilands camp to ARN. ARN accepted that deed. They signed it and returned it. And so essentially at that point you had settlement, and indeed consistent with that, the Sandilands camp then executed the deed in the same form. So there was no compulsion here.
So they didn't need to file the affidavits. They were 6 days late. They filed them on the same day as the settlement. So why'd they do it?
It's a great question, Rob. It's like that TV series. Remember the one that Leonard Nimoy used to host, Great Mysteries of the World? They talked about the Shroud of Turin and the airstrips in Peru and all that kind of stuff. It's one of the great mysteries of the world as to why those affidavits were filed. I don't know. The judge,
well, I think I know,
alludes to this. He adverts to this and says, well, he says there's no purpose in conjecturing about it, Rob.
Well, he may have no purpose in conjecturing, but I certainly do. And I should have brought the tinfoil hat because I'm not usually into conspiracies.
No, I'm not suggesting it's a conspiracy theory.
This is. Because I think this is a classic case of revenge. Think of Kyle and Jackie O as exes. She's done him wrong. She's left him. And he doesn't want to look like an arsehole. But think about this. Is this a clever way of being able to provide evidence against Jackie without looking like you're trying to give evidence against her? It's revenge without wanting to look like revenge. You get to put your things forward, and I'll tell you this as well. There's no way Kyle wants her to walk away with more money than him, because that would be a slap in the face and he would look like a loser. She's already broken up the marriage. And so if he gets to look like the nice, I don't know what happened. I'm at a loss. You know, I still love her. I won't have anyone say a bad way. But here's all my evidence. You take that away, Your Honour, and here's everything I want to say about it. But I'm only doing it because I'm forced to.
So that's an interesting theory, and it's certainly not a conspiracy theory. I think.
Well, come on, he's got good lawyers. They knew he didn't have to file these affidavits.
There's merit to that theory, in that if you did want to throw a hand grenade, if Kyle wanted to throw a hand grenade to Jackie, one way of doing it would be to file the affidavits. Perhaps where your theory goes wrong, and we should make it clear, it's just a hypothesis. Where your theory potentially, Rob, goes wrong is that Kyle opposed the use of these affidavits in Jackie's proceedings. So he put up resistance to that. Now, are you saying he ran dead with that?
Compulsion. Again, I'm trying to stop these affidavits being used, Jack, but what can I do?
Well, but Kyle's lawyers opposed the application by ARN to use them in Jackie's proceedings. and stated that case vigorously in correspondence. So that does run counter to your theory. I don't know why these affidavits were filed. It might be because the case management hearing was imminent and they thought it's just too late to not file them in case we have to appear.
I'm going to pull you up, Michael,
like
and I love you very much, but Justice Stewart said,
I know.
The Sandilands parties opposed the relief sought by the respondents, i.e. ARN, to have the affidavits, but the Sandilands party have not appeared or offered any submissions other than what is in the letter in support of that opposition. I come back to what I said at the very beginning. It sounded like Kyle went, I'm fighting to keep these affidavits. Here you go.
Well, that's an interesting theory. That's an interesting theory, and
I refuse to believe lawyers as good as his didn't know what they were doing. And if they didn't want those affidavits going to Jackie's case, they would have been there fighting tooth and nail for it, and they didn't do that. But go on.
Well, I can only take it on face.
I'll give you the last word.
I can only take it on face value, which is that, interestingly, Kyle's lawyers opposed the use of Kyle's and Bruno's affidavits in Jackie's proceedings. Interestingly, Jackie did not oppose ARN's application. I think they took a pragmatic view of the relevant law and formed the view that it would be unlikely to be successful because the affidavits were not produced under compulsion and therefore the protection didn't apply to them.
Which Kyle's lawyers would have known.
Well, they argued a different proposition in their correspondence. So it is what it is. I mean, I do think that what does make sense is the notion that Kyle's camp consider the matter to be at an end. They're done with it. And so one reason why they may have opposed vehemently, vigorously, the use of the affidavits in Jackie's proceedings is they did not want the possibility of being called as witnesses in those proceedings.
See, I don't think that's going to happen. I think Kyle's too much of a wild card. And I don't think ARN or Jackie would call him as a witness. ARN, I think, I don't know I can't remember what's in the affidavit specifically, or whether, have we seen an updated affidavit?
No, they're not been released. They've not been released, Rob.
So my point is that if ARN can use his affidavit as evidence, then that's a better scenario for them than calling him in.
But you don't get to do that, really.
Right.
You might be able to use some parts of it in certain ways without calling him as a witness. But if you're going to, the general proposition is this: if you're going to rely upon evidence from a deponent, from a witness, then you need to make that witness available for cross-examination.
Gotcha.
You don't get the benefit.
So that they can be cross-examined and their evidence put to the test.
Exactly. So that if, for instance, there's material in Kyle's affidavit, and I suspect there is, about the nature of his relationship with Jackie and that perhaps Jackie gave as good as she got, or that she responded vigorously to things that Kyle had done in the past, and their relationship was more robust than is now being portrayed. If that sort of evidence, let's assume that evidence is in Kyle's affidavit, and I suspect it is, and ARN want to lead that evidence, it's not just a matter of them saying, well, here's Kyle's affidavit from his proceedings. We read paragraphs 20 to 30, and, Your Honour, we expect you to just accept that evidence. Jackie's lawyers are entitled to say, well, hang on a minute, where is Mr. Sandilands? Because we want to cross-examine him about those matters. It is unfair for the court to have regard to that evidence unless we're given an opportunity to cross-examine him. And it may well be, so that's an interesting turn of events if that occurs. But it may well be that, and it's entirely conceivable, I would have thought, that Kyle in particular, Bruno, want really nothing to do with Jackie's proceedings or their own, or Kyle's proceedings anymore. They want to focus on the project that's about to launch, and don't want to be drawn or dragged back into it. And so presumably, did instruct.
I don't know. It's more publicity. And because there's one more twist to this. If we keep the tinfoil hat on for a moment, and by the way, I'm ruling in your favour on that one, so you win that round. Okay.
No, it's not a contest. It's not a contest, Rob, but it's your show. You can do it as you please. You can have a scoreboard if you like.
No, I love our chats. That's why I can have a bit of a piss take with you. But there is another element to this, which has me thinking, because Kyle has openly been saying that he and Jackie have been secretly texting each other against the advice of their lawyers. This raises a couple of issues for me. Surely ARN will want to subpoena those texts and see what has been said. And depending what's in those texts, if Jackie was so traumatised by Kyle's behaviour, why is she texting him at all? Now, look, she may just politely be replying. That's a thing. But if she's going beyond that and engaging in conversation, well, surely that hurts her case against ARN. So this would be another grenade that Kyle is lobbing into the fray.
So taking each of those propositions in turn, you're right. These may well be messages that are subpoenaed or subject to a notice to produce from ARN, where they call upon these messages, texts between Kyle and Jackie, such as they are. What inference can then be drawn from them is going to depend very much as to what's in them, on what's in the text messages. So the fact that they might be engaging in some cordial texting does not necessarily mean that on 26 February, what was written in the complaint letter is no longer valid, or wasn't valid on 26 February at that time. And what matters is what was stated at that time, rather than what has occurred subsequently. So I would imagine that the content of those text messages is only going to be relevant insofar as it casts a light on the state of affairs as at the relevant dates, 20 February, when the incident occurred, 26 February, when the complaint letter was filed, 3 March, when there was the repudiation or the termination of Jackie's services agreement on the basis of the asserted repudiation. And then there was a further letter from Jackie's camp to ARN asserting that they got the wrong end of the stick in relation to the 26 February letter, and it wasn't a repudiation. So they to me are the relevant dates, and what happens subsequently is really only relevant insofar as it casts light on the events of that time.
Okay.
It might be relevant. It might be relevant in relation to perhaps damages, or if Jackie is saying she's been significantly psychologically harmed in some fundamental or material way, and let's assume, and of course speculation about anyone's health, particularly a woman's health and mental health, is an unsavoury thing, but for the purpose of the discussion and speaking generally, if someone was to say, well, I've spent the last few months since this in a fetal position, in a darkened room, the very mention of his name somewhere sends me into, triggers me, got PTSD. But then, and I'm speaking generally here, but then evidence is adduced that actually you've been texting with the person, you've caught up with them for lunch, you've gone to see a movie with them, etc. And obviously I'm just running a hypothetical here. I'm not suggesting Jackie has done any of that, but just to answer your very good question, if there is conduct that's been engaged in which is inconsistent with an assertion about a state of mental health or physical health, then that is something that could be grist for the mill in terms of cross-examination in relation to damages, compensation and the like. But in terms of the actual liability, the outcome of the main case, the liability aspect of the case, that will really turn on events in February and March. And obviously, to the extent the February letter refers to previous incidents, August and September, events at that time.
Yeah, look, I am usually one when people say, oh, they planned all this, they planned all that. I'm always like, I've been in these rooms. No one's smart enough to plan these kind of manipulations. But Kyle's lawyers are smart. And
absolutely,
I believe, and I'm happy to be incorrect on this, and I hope I am, but I believe these affidavits were put out there for a reason, the way they were, and I do think there's a bit of inflicting damage going on, but I could be wrong. Michael Byrnes from SWAAB, almost called you Michael SWAAB. You're very suave, though. Michael Byrnes from SWAAB. Thank you for indulging my conspiracy theories tonight. Always appreciate your insights. Thanks for joining us on Media McKnight.
Thanks, Rob. Always a pleasure.
I love my banter with him. Anyway, that brings us to the end of this edition of Media McKnight. Don't forget, new episodes upload every Tuesday at 8 p.m. Australian Eastern Standard Time. And if you are a member of the McKnight Tonight YouTube page, a paid member, you get them as soon as they're ready. So just go to youtube.com/@McKnightTonight. All right, until next week, I'm Rob McKnight. I hope to see you again soon. Cheers.